a second. Starting. There you go. Recording has started.
Thank you. Good evening, everybody, and welcome to this webinar on judicial reviews, everything you ever needed to know and haven't been able to ask. We're very grateful that Karen Phull, a partner at Farrer & Co, has agreed to speak to us this evening. She specialises in planning in the environment, and she volunteered to do this for us, so we're very fortunate. And she's going to cover literally everything from the cost of a JR to the grounds, the practicalities, all the things you can think of. And as we've said, put your questions in the Q&A if you have access to it, and in the chat if you don't. And we will also, as it's recorded, it'll be on our YouTube channel, and I'll try and put that in the chat. The chat was broken for me a minute ago, but I'll try anyway. So we'll take all the questions at the end, and I will hand over to Karen now. Thank you, Karen.
Thanks, everyone. Yes, I'm Karen Phull. I'm a partner specialising in planning law at Farrer & Co. So over the next hour, I'm going to be talking about judicial review in the context of planning permissions that have been granted by local planning authorities or councils. And I am going to be focusing primarily on the role of the claimant. So that's the party that's bringing the proceedings against the council, requesting that the planning permission should be quashed. So over the next half an hour or so, this is what I'm proposing to cover. Apologies to those of you in the audience who are familiar with or have experience of JR. So my talk assumes that you have little or no experience of JR. So I'm going to start by explaining what it is, and then go on to set out the process, including what happens if you win or lose. I would like to cover the Senior Courts Act defence, as this is very commonly used and can often lead to JRs being dismissed. I'm going to finish up with some case law examples so that you can see planning JRs in practice, and also with some practical tips, including how to deal with costs. So what is judicial review? So judicial review is a legal process. It should be a last resort where you're requesting that the High Court considers whether the council acted lawfully in granting planning permission. Now, there is a specialist planning court that sits within the High Court. It was set up a number of years ago. It's very important to stress that the court isn't there to consider the planning merits of the application. They will only intervene if they consider that a serious error has been made, and they're not there to substitute their own decision. If they quash the planning permission, it's sent back, the application is sent back to the council, or the appeal is sent back to the planning inspectorate for it to be redetermined. And whether or not the court decides to quash the planning permission is entirely at their own discretion. And some of the factors that they will consider in exercising this discretion is your conduct as the claimant, whether quashing the planning permission is actually going to cause prejudice to anyone, but also other factors that I'll come on to later as well. So in a nutshell, JR is primarily looking at whether a serious error has been made, and that typically includes the council taking irrelevant matters into account, or it could be that they have misinterpreted their own planning policies, or that they failed to apply them correctly. So let's start right at the beginning. The planning application's been submitted, and although it's not always possible, where you have been notified of the planning application, please make sure that you object to the application and set out your points as fully as you can. Even if it's a late objection, it's still better to object late. This is because courts tend to frown upon claimants that bring a JR but haven't bothered to object to the planning application setting out their concerns. I appreciate that for some of you, you didn't object to the planning application perhaps because you weren't told about it. That's a completely different ball game. But clearly, where you do know about it, then you should do everything that you can to object. Most councils have on their planning pages some guidance as to what can properly be included in a planning objection. Primarily, you should consider whether the application is in accordance with the council's local plan. So you might have matters relating to loss of privacy, there might be unacceptable impacts on conservation areas or listed buildings, or you might feel that the mass or scale of the development is excessive. You don't have to appoint professionals at this stage to submit the objection for you if that's not really a feasible option. I know some parties do, but bear in mind that your objection letter is going to be in the public domain with your name on it. So if the council decides to grant planning permission, it's really important to keep an eye on the council's website, because you only have 6 weeks to file your claim, and that 6 weeks runs from the date of the planning permission. So that's the date on the face of the planning permission. That's when the clock starts to run. And it's not always the case that the council will publish the planning permission on their portal immediately after granting it. So you might already lose a few days to begin with. If you really are considering JR, I do this with all my clients that appoint me to do this, do get council's input at the outset. It's better to spend a smaller amount of money at the beginning to flush out a weak claim if your claim happens to be weak, so that you don't waste larger sums of money going forward. You could sort of roll up those instructions so that if council thinks actually yes there are potentially grounds here, then he could immediately draft a pre-action letter if there's any merit in your claim. There is a judicial review protocol that requires you as the claimant to send a pre-action letter to the council. It needs to be copied to the interested party, which is the planning applicant, because they stand to lose their planning permission. And that pre-action letter sets out very briefly why you think that the council has granted the planning permission in error. So you're setting out very briefly your legal grounds. You're setting out which policies they failed to apply correctly, which ones they forgot to take into account, any procedural errors relating to failure to publicise the application or to consult certain statutory consultees. Whatever errors you uncover forming your grounds would go into your pre-action letter. And you'd also set out the remedy that you're seeking. And normally for planning JR, you want the planning permission to be quashed, and you want your costs in bringing the claim to be reimbursed. Now, normally you allow 14 days for a reply, so you can see how this is really eating into your 6-week period. I do appreciate it's not always possible to give that 14 days for them to reply, and I have certainly seen pre-action letters that offer very little time at all to respond. But the reason why you want to try and comply with the protocol if you can is just so that you're not facing any costs backlash later on from the court. And you should really consider the reply from the council and the interested party to your pre-action letter before deciding whether to file your claim. Now, in some cases, the council will, in their response to your pre-action letter, concede to the error and agree to your bringing proceedings and the planning permission being quashed. But in most cases, they tend to defend the decision to grant planning permission. The other point I wanted to make about pre-action letters is that by firing off a pre-action letter, you haven't started proceedings, you haven't committed yourself to a JR. So, I mean, I've certainly had some clients that have taken the approach where they want to sort of flush out to see if the council would respond in a way where they do concede. So if you fire off a pre-action letter and you receive the response and you decide at that stage, well, I don't want to proceed with a JR, that's fine. You can stop at that point. You're not looking at cost awards against you because you haven't actually filed anything in court. So it's perfectly acceptable to do that. So assuming you've sent your pre-action letter, you've considered the replies, there's nothing in there that worries you, what exactly are you filing within 6 weeks with the planning court? So the primary document is going to be the claim form, which needs to be signed and dated. So that sets out the details of the planning permission that's the subject of the claim. It would also list all of the relevant parties. So the defendant will be the council that granted planning permission. The interested party will be the planning applicant and any other parties that might be relevant. Your legal advisors will draft a statement of facts and grounds, setting out the legal grounds on which you're bringing the claim, which in most cases will mirror what was in the pre-action letter, although it will be a bit more detailed. Or you might have decided, you know, after you received the response to the pre-action letter that you're going to drop one of your grounds that you referred to in the pre-action letter in the actual statement of facts and grounds, and that's perfectly acceptable to do. You might also want to include a witness statement. So this could be a statement from you as the claimant explaining how you became aware of the planning application, introducing all the relevant application documents as exhibits, and outlining any other points that you think are relevant for the court. So any impacts of the proposed development that are very particular to you, for example, you would put that into your witness statement. Now, bear in mind, you are supposed to put all your evidence in at the beginning, so within that 6-week period. So you should end up with a paginated and an indexed bundle of documents, and that should include the planning application documents, obviously the planning permission itself. If there's a Section 106 agreement, that needs to be included. The pre-action correspondence I've just mentioned, and any other relevant correspondence that you've had with the council or with the interested party. You'll also need to include the relevant parts of the local plan, so the policies that were referred to in the officer's report or the committee report or on the face of the planning permission or in your planning objection letter, and any case law and legislation that's being relied on. The courts are very keen to ensure that only relevant documents are included to ensure that parties aren't unnecessarily flooded with excess paper. Now, all of this means that you've got quite a lot to do within that 6-week period. It's a very front-loaded process for the claimant. You have to go off and get legal advice, you're firing off a pre-action letter, you're considering responses, you're gathering your bundle, you're drafting your witness statements, and you're trying to file it all within 6 weeks. So it is quite a lot to do. And generally, as a matter of course, when I'm dealing with JRs, I'll aim to have it filed within 5 weeks, and that's probably just because I'm a very cautious lawyer, because inevitably things crop up, and it's better not to aim to get it in on the last day and then for things to potentially go wrong. So you filed your claim form in the High Court and with your bundle within that 6-week period. So the court will stamp your claim forms, and you need to serve a copy of that stamped or sealed claim form on the other parties, together with a copy of the bundle that you served on the council, that you filed in the court within 7 days of the claim being issued by the court. So taking that stamped form and serving it on the other parties. Now, this is a really important distinction. The 6-week deadline to challenge the grant of planning permission applies equally. So whether that's a decision by the council to grant planning permission following a planning application, or whether it's a decision by the planning inspectorate or the Secretary of State to grant planning permission following a planning appeal, so that's where, the council has refused the application or failed to determine it, and so it's gone to the planning inspectorate. The 6-week deadline to file your claim applies to both. However, that extra 7 days that you get to serve the claim form and bundle only applies to JRs where you're challenging the council's decision to grant planning permission. If your challenge relates to an inspector's or Secretary of State's decision, that's known as a statutory challenge. And for that, in that 6-week period, you have to file and serve your claim. So essentially, you're losing that extra week. And that's really important to remember, because people have forgotten that in the past, and then that invalidates your whole claim and, all the hard work that you've put in. So the defendant, that's the council, and the interested party has 21 days to respond to your claim by filing an acknowledgement of service. So the acknowledgement of service basically indicates whether or not they intend to defend the JR. So there could be a variety of outcomes at this stage. For example, the council might indicate that they have no wish whatsoever to defend their decision. And in those circumstances, you want to check that the interested party doesn't want to continue the fight. On most occasions, they don't. It depends on the size of the development. But it's certainly something that you'd need to check with them if the council said, well, we don't intend to fight it. Equally, the council might decide that they do want to defend the claim, and the interested party can decide either to take part actively or alternatively sit back and watch and wait for the proceedings to play out. There's no compulsion on the interested party to take part in the JR proceedings. There's various schools of thought as to what they should do. Personally, when I'm acting for interested parties and it's their planning permission that's under threat, I would usually advise them to file an acknowledgement of service, because there are certain matters that only they can speak to. For example, the prejudice that's going to be caused to them if the planning permission is quashed, which I wouldn't expect the council to address with the court. So the court's now got the claim form, they've got the bundle, and they've got any acknowledgement of service that's been filed by the council or the interested party. So the court now needs to decide whether or not to give permission for the JR to proceed. So they're going to look at all of those papers and decide what they want to do. So this is a filtering process known as permission on the papers. And there are a number of outcomes at this stage. Firstly, the court could decide that the claim is totally without merit, which is probably the worst decision that you can end up with as a claimant, because the matter's thrown out completely and there's no right of appeal. The next step up is where the court decides to refuse permission to proceed, but it's not totally without merit. And if that's the case, you've got 7 days within receiving the court order to renew your application for permission to proceed with the JR. So you can ask again, and following your renewed application, the court can decide at that stage whether they want to change their mind and give you permission to proceed or not. Alternatively, the court might decide at the outset that, having read the papers, they think there is at least an arguable claim and permission to proceed with the JR is granted. At that stage, you'll be issued with correspondence from the court, which indicates that whether or not you've been given permission to proceed. But the full hearing usually doesn't take place until later, so that's where your barristers will all stand up and argue their points. In some cases, you do have a rolled up hearing where the court decides in one go whether they're going to give you permission on the papers, and then they'll immediately proceed to a full hearing to decide, to look at the grounds that you've raised, to let all parties sort of argue their points and to make a decision about whether or not to quash the planning permission. So after the full hearing, the court's now going to decide whether or to allow the claim, and if that's the case, they usually quash the planning permission or dismiss the claim, in which case the planning permission remains intact. Now, it's usually the case that the losing party has to pay the winning party's costs. The rules relating to costs are quite detailed. Generally, the court doesn't like to make a double award of costs against the claimant. So this is where if you lose, you as the claimant, you'd be expected to pay the council's costs because they had to defend their decision to grant the planning permission. If the planning applicant, as the interested party, took a full role in the proceedings, other than the costs of their acknowledgement of service that they filed way back at the beginning within 21 days, that they're unlikely to recover any costs above that unless they brought something new to the table in fighting the claim and it was their point that won the day and was successful in the planning permission remaining intact. So before you have the full hearing, all of the relevant parties will have submitted a cost schedule that sets out what's been incurred in terms of costs. And if the parties are able to agree the amount of costs between them, that can be included in the court order. Otherwise, the court order is just going to say that the claimant will need to pay the council's costs to be assessed if they can't be agreed. So if the costs are going to be assessed at a later date, what normally tends to happen in practice is that there'll be correspondence going back and forth with the council to try and agree a figure, to try and settle a figure between you. But ultimately, if you can't agree what you should be paying on costs, you can ask the court to assess the council's costs if you think that they are excessive. The same rule applies the other way around. So if you, as the claimant, you win and the planning permission is quashed, the council has to pay your costs. So the same rules apply there. Now, I've mentioned there that the quashing of the planning permission is at the discretion of the court. They'll take into account the conduct of the parties. So, for example, if the claim was filed late or a pre-action letter wasn't sent, or there is going to be substantial prejudice caused to the planning applicant if the permission is quashed. These are all relevant factors to be considered by the court. I also mentioned at the start of my talk that it's really important to object to the planning application so that you can demonstrate that you did everything you possibly could to try and get the application refused, and also to bring attention to the points that you wanted to raise in your objection before the application was determined. That's also relevant, the objection letter, to be able to demonstrate that you as the claimant have sufficient standing to bring the JR. So, the fact that you live close by and that you objected is all very helpful to demonstrate that you have good reason and a sufficient relationship to bring these proceedings. Bear in mind that even if the planning permission is quashed, the planning application is going to be redetermined by the council unless the applicant chooses to withdraw the application. So this can sometimes mean that it can sometimes be a hollow victory. Say, for example, where the planning permission is quashed on a procedural error that can easily be remedied. So do bear that in mind when thinking about the practical commercial angle and whether you want to spend money on litigation, because you might have gone through this very long and expensive process to have the planning permission quashed, and then the application redetermined, correcting the error that the courts had identified, and resulting in the planning permission being granted again, but this time in a robust fashion. There is also a right of appeal if your claim is dismissed, so you can ask the court to give permission to appeal to the Court of Appeal. Whether or not you want to go down that route at that stage really, depends on legal advice and costs going forward. So this is a flowchart. It's definitely not my own work. It illustrates the whole JR process that I've been through, which I hope is very helpful. I mean, the whole process can be quite lengthy. So if you're a claimant, once you've filed your claim, you might need to wait a number of months, 2 or 3, perhaps longer, before you find out whether you've got through that initial filtering process and being given permission on the papers to proceed. And then after that, you could be looking at another 6 to 9 months before you have that full hearing where the substantive points are heard in respect of your claim. Now, until there's a final decision by the court to quash the planning permission, during this whole process, the planning permission does remain intact. Although the applicant, because you have notified them, because you sent your pre-action letter and you served the papers and the claim form on the applicant usually won't rely on the planning permission and start building, just in case it later disappears when it's quashed. So I wanted to talk about the Senior Courts Act defence. It's a defence that often crops up in many planning JRs. It's very commonly used by councils and interested parties, where they argue that the outcome wouldn't have been any different if the error hadn't occurred. So, for example, if there was a procedural error with the application because the council forgot to notify a neighbour of the planning application, and he wasn't formally given the opportunity to object. But if that neighbour became aware of the application through other means, that would be an obvious one for the council to raise and say, well, actually, yes, we admit we made a mistake here, but the neighbour was made aware of the application through other means, and so we don't think it's a fatal error. Often claims will also include allegations in respect of the officer's reports or committee reports that might have been written in a sloppy manner, where they're not always very clear. When the court might decide that even if that's the case, actually, although it wasn't a perfect report, because they rarely are, the outcome of the planning application wouldn't have been any different. So where this defence is considered to apply, the court can refuse to grant the relief you're asking for, where you're asking for the planning permission to be quashed, unless they think it's appropriate to do so for reasons of exceptional public interest, which is a very high bar. But just looking at a couple of cases, I thought I'd start with this one, which is back in 2010, which I thought was quite interesting, where a planning permission had been granted to convert a grocer's into a takeaway that just happened to be right next door to a secondary school. And the school had embarked on this healthy eating initiative, and obviously all the kids piling out at 3:30 to have burgers and pizza doesn't really help support that initiative. So one of the objections highlighted the school's health concerns and the healthy eating initiative, but members were wrongly advised at the planning committee meeting that the proximity of the secondary school to the takeaway was not a material planning consideration, basically that it wasn't relevant at all to the determination of the planning application. And the court held that in determining the planning application, the council clearly had to have regard to the development plan and to determine the planning application in accordance with it, unless there were material considerations that indicated otherwise. Now, there isn't a statutory definition of what is a material planning consideration, so it's up to the decision maker to decide what they should be taking into account. And the court also noted that there have been earlier judicial decisions which clearly states that promoting social objectives can be a material consideration. Now here, as the planning officer had given a clear direction to committee that the proximity of the takeaway to the school shouldn't be taken into account, this was bad advice that could have influenced the committee, and had they been properly advised, they might have reached a different decision, and for this reason the planning permission was quashed. The next case I want to discuss is one that was a more recent one. It was determined last year. So Cornwall Council decided to grant planning permission to expand a golf and country club in an AONB. The planning permission authorised the construction of a function room, various alterations to the existing building, creating staff accommodation, and 2 separate detached buildings to house additional guests. The planning application received a number of objections, focusing on the impact that the club's intensified use could have in terms of noise, traffic movements and light pollution. Now, the Cornwall AONB unit also expressed a number of concerns, and they considered that the proposal would detract from the wild and remote character of the location and the quality of the place. The country club, however, pointed out that the business had a long history of failure, and they'd hoped that this would, turn things around by improving facilities, making accommodation available so that they could host weddings. And the key document in the JR was the officer's report that was written prior to the grant of planning permission. And the court felt that the officer had taken into account all of the relevant considerations, including those concerns that had been raised by the AONB unit and the potential traffic and noise impacts. Although the objectors asked the planning officer to impose conditions to control the intensified use, the officer chose not to do so, and the court was reluctant to interfere with the planning merits of the council's decision. So this is a good example of the general view taken by the courts, that if you are bringing a planning JR, you really do need to point to a fundamental error. Generally, the courts don't like to interfere with the decisions that have been made by councils where there's just a difference of opinion on planning merits, and the court held here that all the relevant factors have been taken into account by the planning officer, and a reasoned decision had been reached. So, just finishing up with some practical points, which I hope you'll find useful. The first relates to, well, quite a lot of them actually relate to costs. So when you're submitting your JR claim, you can ask for a cost cap. So this would mean that if you were unsuccessful in the claim, it limits the amount of money that the council can recover from you. It does mean that a reciprocal cap applies. So let's say, for example, if you lose your case and you ask for a cost cap of, I don't know, £5,000 to £10,000, if you get that cost cap, then it means that the council can't recover more than that from you. But if you win, there is a reciprocal cap on you, so you can't recover higher than a certain amount with the council. And I think it's off the top of my head. I think it's about sort of £30,000 to £35,000, so that's still quite generous. Obviously, if you are seeking a cost cap, then you need to be transparent and open with the court about your financial resource, and you need to demonstrate that you have good reason to ask for this cost cap. So if you have significant sums of money in the bank, then you will need to disclose that with your cost cap application. My next point, litigation is a gamble. Focus on the planning application process. Really, what I'm getting at there is litigation is a gamble, and I would strongly advise that if you're in a position to put 110% into the planning application process and potentially getting it refused, that's a better outcome, because JR can be it's down to the luck of the draw at times. I mean, I've obviously made the point that you need to point to a serious error, but some of it can come down to which judge you get on the day, and it's obviously a very long process. It's costly, and you're much better off trying to focus on the planning application if you can, and trying to get it turned down. Be really clear on your legal budget. So make the best use of your advisors. If there are things that you can do, basic admin, do that yourself, because otherwise you're incurring costs for fairly simple tasks, and which just doesn't make any sense. So do be clear about what you want to use your advisors for, and what you you can do yourself, and also get some help from the local community. I've mentioned their fundraising. So either I've had groups come to me where there's probably 8 to 10 key people who've put their hands in their pockets and come up with a fixed amount of money per person and sort of pooled that. Or alternatively, we're seeing quite a lot more of social media funding. So GoFundMe pages is becoming quite common with planning campaigns. Sticking with practical points, do also think about other options outside JR. So, for certain clients, I know it's not always possible, especially if you're looking at, a large housing site that's been allocated in a local plan. That clearly it's not, it's going to cost an enormous amount of money, way more than a JR to buy the site. But if there is an opportunity to acquire land, are there any other remedies available to you? So in the past, we've had clients approach us where they want us to advise on planning objection and possible planning JR, but at the same time that they will ask my colleagues to look at the title to the land. Are there any restrictive covenants or easements or rights of way that could potentially stop the development from proceeding, even if it does have planning permission? So think outside the box. For campaign groups, do make sure that everything is in order in terms of your constitution and your governance provisions. If you've got a chairperson, where is it in your constitution? What governance provisions do you have that stipulate that the chairperson can make decisions on behalf of the group? Are you a limited company? Are you an unlimited company? Are you just a group of people? Think about how you set yourself up, and do all of this before you get to the JR stage. I've also seen campaign groups who are really very good at making use of expertise in your community, and I appreciate that it is different in every community. In some communities, you've got some highly engaged people who are all contributing. In others, you've got one person sort of taking the lead on things and not getting much help from others. But if you've got planning consultants and lawyers and other professionals in the community, do make use of them, because they can be very effective in helping you with your campaign. don't rely on the council to tell you when the planning permission's been granted. So the onus will be on you to check their website daily, just to make sure that you're not losing any time in that 6-week period. And I also wanted to mention a very good publication that you can find on the court's website, called the Administrative Court Judicial Review Guide 2022. So it's very recent. It's really very good. It's got links to all of the forms that you need. It's got the telephone numbers and addresses for the court office. It goes through the procedure. It's got the flowchart that I showed you on one of the earlier slides, and there's enough detail there to get you through the process. Finally, not on the slide, I just wanted to make a quick mention of Planning Aid and ELF, which is the Environmental Law Foundation, which Rosie and her colleagues may already be familiar with. They're very good at providing pro bono advice, and especially ELF. You might be able to approach them to ask that perhaps even the initial view on the merits of a JR where you need some legal advice could be done potentially for free. Right. That's all from me.
Brilliant.
Hey, we've
Thank
got
you so
quite a few
much.
questions.
Okay. I'll do my best.
So Caroline, do you want to go first with the chat? There's a couple in the chat, aren't there?
Yeah, let's now the first one, and then actually got a lot of response saying, oh yes, that's a really good question.
Agreed.
Was from Tony, and he asked, the district council's 5-year housing land supply were not adequately endeavouring to report it. Statement was issued which was seriously incorrect due to some calculation errors. There was also a series of interventions by a new officer that was suppressing the number. A working group has been set up to investigate, I presume that's at the council, but until a new annual monitoring report is issued, the tilted balance still applies. The annual monitoring reports have not been scrutinised by the councillors prior to publication. So the question is, are any applications that are then permitted under the tilted balance because of this purported lack of a 5-year housing land supply? Could this potentially erroneous, and Tony says, or indeed deliberately biased position be challenged under judicial review?
Oh gosh, that's a very good question, and a really complicated one to start with. Thank you so much. There's a whole load of points in there. I mean, I suppose you've got, just thinking it through, you've got some data that's clearly incorrect and points to a lack of supply, and people are sort of latching onto that and getting planning permission. Whether or not the court would then, I mean, there's an obvious ground for JR, because one of the grounds that's sort of commonly argued is that you're taking into account incorrect information. I mean, it sort of begs the question, why is something not happening sooner in terms of at least potentially alerting? I mean, it might just be that the council's not at the right stage to be able to sort of summarise where they've got to and where the errors are, and that there's still this ongoing process to be able to put something on the website to at least alert people to the error. But certainly, I mean, that's an absolute minefield. It would be, an absolute godsend for a barrister who was looking at a JR, because I can see that there's obvious mistakes that in a statement that people are relying on, and using it to try and get planning permission.
Actually, and that brings me on to a question of my own, but it fits neatly in here, so I will ask it here. How close does the relationship have to be to the planning application? So, for example, if we were looking at a case like that, could a group like us, like Community Planning Alliance, bring a judicial review as a sort of matter of principle, even though we weren't directly related in any way to that specific application?
There have been groups that have bought judicial reviews. So, for example, when the PD rights were changed, there were and there was changes to planning legislation to bring in all sorts of changes. This is around about the time of the pandemic, which included new PD rights to build additional stories on buildings. You had interest groups like yourselves bring claims in those circumstances as well. So, I mean, normally for planning applications, you do have to demonstrate a relationship. But if we're zooming out and we're looking at policy statements or new legislation, then yes, you can see how interest groups could come forward potentially and argue that they have sufficient standing to bring the claim.
Okay, thank you very much. Mike asked a question about what are the relative merits and risks of pushing for a public inquiry where even if you win, the minister can overturn with relatively few grounds the challenge, or B, letting the application go forward to the planning committee and then seeking to a challenge with a judicial review.
Yeah, I think this is a really difficult one because I've had clients ask me this question before. Should we try and get the application called in? And it's really tricky because until you get a clear indication, I mean, the only circumstances where I think that could potentially be useful is where if you have some information or you've had a clear indication from the officer, or you think actually this is going to be granted by the council. That's probably the only time I would be asking for the application to be called in. There were some very interesting statistics published a while ago now, actually, which demonstrated that the closer you are to a general election, the more call-ins you'll see and recovered planning appeals. So that might be a relevant factor as well. But it is very difficult because you could ask for it to be called in, and then actually they were going to refuse permission anyway at the local authority level. And generally, I mean, as we're in a period where there are no general elections at the moment, generally the Secretary of State doesn't like to interfere with local authority decisions. So you might ask for a call in and find that it doesn't happen anyway, in which case potentially you've shown your hand, and the council knows it's not going to be called in. So it really does depend on the facts of the case and what information do you have, because I've had many clients approach me and say, oh, the council are definitely going to grant this application. It's going to happen. We know it's going to happen. We want you to help us to object, and then potentially JR, and it's refused by the council. So don't necessarily assume that a call-in is going to work, and think very carefully before you ask for one.
Thanks, Karen. And Nick asks, he says, my application for a JR was refused on the papers. A renewal was requested and the judge thought there was an arguable case and it raised more than local issues. The head of the administrative court disagreed and refused permission. I assume refused permission for the JR. An appeal was submitted to the Court of Appeal, but they again refused permission to hear the appeal. Is that it, or is there any other mechanism to challenge the local planning authority's decision?
No, I think you're probably done. You've exhausted your rights of appeal with the court. I'm assuming it's in connection with a planning permission that's been granted, which is now intact. You brought your challenge and it didn't succeed.
I will sadly, hopefully Nick heard that, sadly. Kate has an easier question. Well, it may not be an easier question. She says, where can we look for best examples of case law? I assume she's trying to sort of do some of the donkey work herself, but
I would try there are some good planning chambers. So you know, where you have all the planning barristers, they often have resources on their website. So chambers like Landmark and 39 Essex and Francis Taylor Buildings, they'll often have blogs and resources on their website where you can, you can read case law reports that they've prepared. Often a lot of them will, they'll all have marketing departments, so you can email the marketing department and ask to be put on a mailing list so that you're getting emails, you're receiving emails automatically from them, and which is great because it sort of keeps you up to date with the most recent decisions coming out of the courts.
Brilliant, thank you, Karen. And then the last one coming from the chat was from Charles, who said, are you able to explain the Heir House Convention claim procedures for costs on a judicial review?
Well, I mean, I'm sort of dealing with one at the moment, not where I've made the application for a cost cap, but it's my client's planning permission that's under threat of being quashed, and there are it's all in the claim form. It's quite straightforward in that there are various boxes to tick, and you would address that in your witness statement as well. So you would include in your witness statement what the cost cap is that you're seeking and why you think it's necessary. There are various tests that you need to satisfy, and obviously anyone on the other side can then try and sort of contest your application for a cost cap. But you need to put it into your claim form. So when you put your claim in, you tick the right boxes on the claim form and you put it in there, and then it's up to the court to decide whether or not you should be granted that cost cap. And you might be asked for further information. So if you're not disclosing financial information with your witness statement, such as bank statements and what have you, you're expected to be very transparent and honest with the court about what your financial resources are and how much money you've got in the bank.
So
thank you.
Can I jump in, Caroline, here, because there's a couple of questions in the Q&A about costs. So and Emma says she appreciates every case is different, but could you give us some average ballpark cost for getting to the submitted bundle stage, and any possible costs ballpark for getting to court? And I'm just going to mention the other question as well, just while we're on costs, Aaron. Simon says, when a council goes to JR after PIM's approval, what costs are possible to include in a claim? Does it include council officers' time as well as external counsel and legal and professional planning consultants?
Yeah, I mean, I think with any cost claim, you're always better off because there's always a fight over costs. And whatever figure you claim is going to come down. So my advice is throw in all of your costs, add in your officer time, add in any professional fees that you've had to incur by appointing consultants and what have you, because it will inevitably come down. Whereas if you start making that decision at the outset that, oh, I'm not going to include this, I mean, you've got to be transparent. So you've got to, you'll have a breakdown in your cost schedule of how that time's been incurred and the number of hours spent and what have you. But I would do that rather than not include it and then end up being knocked down on the issue.
What about from their perspective? Sorry, Karen, to interrupt. What about from their perspective? Can they include all of that stuff? So their time, their external counsel.
So sorry, when you say that from their
the council, the other side, if you like, the people that we're challenging.
Yeah, I think that rule applies to well, if it it depends on who's won and who's lost. So when you get to the hearing, you'll all include your cost schedule because you don't know the outcome of the case at that stage. You don't know who's won and who's lost. If you lose, and you submitted a cost schedule, well, you know, that nothing's going to happen with your costs now because you've lost the case, and that's the end of the matter. But if you win, regardless of whether you are the council or the claimant, you know, you will then you should include all of your costs. So whether you're the council or whether you're the claimant, do make sure that you include all of your costs and don't start writing them down at the outset. I don't know if that was what you were getting at.
Okay, no, and I think from I think the question was how much might they put in into their costs, but just in terms of the sort of ballpark costs. What is it going to cost us? Just finger in the air at the submitted bundle stage and for getting to court.
Yeah, I mean, it could vary. I mean, it really depends on where you go. Are you appointing a firm in London? Are you going out to the regions? But you know, certainly I've seen costs of, I've seen people incurring costs of about, you know, 40, 50, 60,000 pounds just to get it into court, get your, because you're getting your legal advice at the outset. You know, you're going to counsel, you're getting counsel's opinion, you've got your pre-action letter, you've got your bundles, and it really depends on how much you're doing and how much what you're using your legal advisors for as well, which is where the crowdfunding is really important. There are things that you can do to try and cut down costs. So, you know, you can try and get a fixed fee. You know, you can there is sort of free legal advice given by ELF, and Planning Aid do that as well, but it is a costly process. So you're, you know, if you're appointing a solicitor and a barrister, then generally the solicitor's fees are sort of incurred up front, you know, in getting the claim into court, and then really the barrister's brief fee, which is, you know, what happens when you end up going to a full hearing, really can vary, and there are chambers inside and outside London, so you need to think about, you know, am I going to approach a set in Birmingham or Bristol, or am I going to London? And, you know, I've seen eye-watering figures being you know, charged at jails, but really it depends on which parties you're acting for. And I think what I would say is because if you're a residents group and you know, money is an issue, then work out what your budget is. You know, I spoke to somebody the other day who was in a similar position, and my advice was, well, work out what your budget is, because, you know, how much money have you got and how much have you collected? Because if you're going to get on the phone to solicitors and barristers, you need to be upfront about what your budget is to see if they can work within your budget, because otherwise you end up wasting time in that 6-week period trying to come up with a fee budget that works. But it's better to be upfront about what resource you actually have. Super.
And conscious of the time, we have got quite a few questions in here, but I'll just pick out another one. One quick question before I ask this. Are there any major differences to taking a JR for a local plan, you know, rather than a planning application? So if you believe the local plan's not followed procedure. And the question that we have in the chat is, what if there is no local plan, and do neighbourhood plans count as well? So in terms of when you're looking at evidence, if there is no local plan, so first question is, are there any major procedural differences if you're taking a JR against the procedures for developing a local plan? That's the first question. And the second question is, when you're looking at evidence, what if there is no local plan, or if there is a neighbourhood plan, should that be part of the evidence too?
Okay, so with the local plan process, if you're bringing a challenge against a local plan, the same deadline applies, but you have got that shorter period of 6 weeks to serve and file your claim. In respect of the and the procedure is other than that is more or less the same, and it will still go to the planning court. On the evidence, which I'm assuming is talking about the bundle that has to be put in within
yes,
the
I think it came in at the very beginning. Yeah.
So if the council doesn't have a local plan, presumably because they just, they've got a really old one that they just haven't updated in a very long time, then you need to be looking at the NPPF, the National Planning Policy Framework, and whatever plan they have, it's because I don't think I've ever come across a local authority that don't have a plan at all. Needs to be referred to. Whether or not you refer to the neighbourhood plan really depends on whether it's relevant or referred to either in the application documents or the committee report or the officer's report, or if it's referred to on the face of the planning permission. So just have a check through, and where you can see references to policy blah of the neighbourhood plan, then make sure you include it. And also, if you're including it on one of your grounds for your claim, then at that point you would include it as well.
Okay, thank you. Rosie, I'm conscious of the time, so
yeah,
although there are more questions, perhaps we can pick these up outside of the session. One final thing is that Clyde has asked whether we're okay to put the presentation itself on our website. Would that be okay with you, Karen?
Yeah, absolutely.
Yeah. Okay, so over to you, Karen. Rosie, sorry.
Yeah. Well, thank you. I thought that was really useful, really clear, and just a brilliant sort of set of instructions about what we'd all need to do, and particularly useful to go early and get as much of sort of involvement with your council as you can at the beginning of the planning application. And for me, the fixed fee thing is really crucial, because if you don't have a fixed fee, you have literally no idea what your cost exposure is, do you? So if you're able to raise that with your barrister or your lawyer quite early on, I think that's very helpful. So yeah, I thought that was brilliant, and great questions, everybody. Thank you for those. So this will be on the YouTube channel. We've just confirmed that the slides will be on our website as well. And thank you very much to Karen. I thought it was brilliant. Thank you, and good night, everybody.
Thanks everyone.
Thank you.
Thank you. It was really good, Karen. Thank you.